excited to welcome you to today's financial webinar on the topic of estate planning, secure your legacy, essential estate planning strategies. I'm pleased to introduce our esteemed presenter, O'Neill Dewey, Partnership Manager at Trust and Will. Trust and Will is the largest digital estate planning platform in the United States. O'Neill's specific focus is on the credit union space, supporting partnerships with 30+ credit unions to date, and providing estate planning education to their 6 million+ members. With that, O'Neill, the floor is yours.
All right. Welcome all CalCoast Credit Union members and the greater community to today's Estate Planning 101 webinar. I'll be your host today. My name is O'Neill Dewey. Believe it or not, my first name is O'Neill, and I manage all of our credit union partnerships here at Trust and Will. I'm joined by Jason from our member support team, who's manning the chat box. So as Will mentioned earlier, feel free to pop any questions into our chat or question and answer feature as we move throughout this presentation, and we'll get to them as soon as they come in. So please feel free to ask your questions. Today, we'll be discussing the basics of estate planning. We'll start by defining why an estate plan matters and what an estate plan is and does. Then we'll cover some of the key documents in an estate plan and how to decide which documents are best for you. And finally, we'll conclude with who needs an estate plan, some of the most common reasons it might be time to create or update your plan, and how you might get started doing so. Once again, any questions, feel free to pop right into the chat within your Zoom screen. So to set the stage for the gravity of the topic today, it's important to know that estate planning is the largest financial personal transaction of your life. That said, it is a piece of financial well-being that is least prepared for by families. Without a plan, most people end up leaving assets and legacies subject to probate, which means the government steps in to make all decisions on your behalf. And unfortunately, nearly 2/3 of American adults procrastinate on their estate plan until it's too late. The three primary reasons for this are: one, a lack of education around the risks of not having a plan, something we hope to tackle today in our presentation. Two, the cost. You can typically expect to pay thousands of dollars to draft simple estate plan documents with a local attorney. And three, inaccessibility. That comes with not really knowing who to turn to get this done the right way. So CalCoast has partnered with Trust and Will to help you through all of these hurdles with our modern and affordable solution. But first, what is estate planning? Estate planning is preparing today for what happens tomorrow. At its most basic level, an estate plan lets you make decisions today about what should happen if you are unable to make decisions in the future. This set of instructions specifies what you want to happen to your assets, your belongings, and your personal body. So why should someone care about estate planning? What should motivate you to actually create your plan or update your plan? There are many reasons to care. First and foremost, peace of mind. You'll feel confident knowing that you've taken the necessary steps to protect yourself and your loved ones. You'll also be able to name legal guardians to take care of your minor children and your pets too. And you'll also be able to prepare for potential incapacity during your lifetime. So studies show that the majority of Americans will be impacted by incapacity either by themselves or a loved one during their lifetime. And because this happens during your lifetime, it can sometimes matter more to people than what happens afterwards. These are inherently personal decisions, so there's no easy way to have a default rule for what matches general desires, and there's no certainty that anyone else would make the same decisions that you might make. When it comes to estate planning, primary motivations can be asset distribution and business succession planning. So diving into each of those, asset distribution is the ability to control where your assets go after your death. You can choose to have assets benefit family and loved ones, to support charities, organizations, and causes that are personally meaningful to you. And you can also plan, your plan can actually help to minimize taxes and maximize the benefit passed through to those beneficiaries. Many people equate estate planning with asset distribution solely, And that definitely is a major piece of the puzzle here, but asset distribution is not the end all be all of estate planning. There's succession planning, end of life planning, and incapacity planning, which relates to your healthcare documents, all of which we will get to later in this presentation. So that's the why, but what is an estate plan? An estate plan is a set of documents containing instructions for what should happen if you can not speak for yourself, whether you're incapacitated or have died. An estate plan typically is made up of multiple documents, not just one. And the documents will vary person to person, but will be tailored to meet your individual needs. Each type of document is designed to do one thing. And your plan could focus on one or two things or a number of different documents. But at the end of the day, these documents should be comprehensive, and you should have a full suite of your selections within them. So most typical documents are wills, trusts, and healthcare documents. So we're going to dive into each one of those separately. Your last will and testament is a legal document that controls most assets when you die. It goes into effect after your death. So what's its purpose? A will handles fundamental needs for everyone. Therefore, if you are at least 18 years old, a will can benefit you. There are three primary functions of a will. First, to determine who will receive your assets after you die. Second, to nominate guardians or for your children or pets. And third, to specify your final arrangements. For example, do you want a traditional funeral or a memorial? Would you like to be buried or cremated? Those sorts of decisions. So what's the next logical decision or a question most people have? What happens if you pass away without a will? The functions of a will are essential. So these decisions must be addressed even if you don't have a will. And so what happens is the state laws will jump in to fill in gaps and make decisions on your behalf. This is one of the most common misunderstandings. Most people assume that default laws will give the same results that you might want anyway, but that's really not always the case. Let me give you an example. You are married with 2 children. Some state laws may provide that your assets are divided 1/3 to each of these family members. And you might not want your kids to receive 1/3 of all of your assets right when you die. Your spouse might not be able to maintain a house or the standard of living with only 1/3 of those assets. So depending on state laws, this is something that could happen if you die intestate. However, with a legally binding will in place, the court will likely honor your wishes as stated. So let's focus more on how a will works after death. Wills go through probate, which is a judicial process to determine the validity of a will and to appoint an executor. If you don't have a will, the court will appoint an administrator to perform the same functions as an executor, which is usually a relative. But if you have no will, that person may not be the person you would have chosen yourself. The executor, once appointed, is the manager of the probate process. Their job is to collect assets, to pay debts and expenses and taxes associated with what's left behind in the estate, and to distribute assets to beneficiaries. But probate is often undesirable because, first off, it is slow. It can take, it was taking 12 to 18 months in California before COVID, and now you can expect 24 months plus in some courts within California. Second, it's difficult and stressful. The process begins immediately after death and begins, and that's during a period of grieving and loss. So it can often create resentment that can lead to disputes within families. And third, it's expensive. In some states, a $1 million estate can cost $50,000 in statutory fees for probate. And so probate avoidance is a huge motivator for some, especially in California. And it is one of the primary reasons that many people look towards a trust. A trust is a legal agreement between 3 parties. There is the settlor or trustor or grantor who creates trust and puts the property into it. There is the trustee who holds and manages the assets in a trust. And then there's a beneficiary who the trust is in favor of. So what that means is that basically the settlor creates a trust and gives assets to the trustee to hold for the beneficiary. There are 5 primary purposes of a trust. First off, to avoid probate. This is key for many people, and a trust can help avoid a lot of those negative consequences we discussed previously. But a trust isn't only about probate avoidance. It can also help you to manage and distribute assets with more control over how those assets are distributed. So you can create contingencies that you can add to your trust. A trust also applies during your lifetime as well as after death. So this means a trust can be useful in planning for incapacity and can ensure there's a seamless transition of control. Fourth, to provide for your family. This is a big motivator for many people with younger children or blended families. Trusts give more control that will eventually benefit your younger children, and they can help to provide for your spouse for his or her lifetime and then ensure that assets pass through to your children after a spouse's death. And fifth, the trust can help to minimize taxes. So what is the role of a trustee? A trustee is basically the CEO of a trust. You're bound by the law and terms of the trust, but it is still a critical role in executing duties. A trustee can work with other professionals and advisors as well. And so when choosing a trustee, you'll want to select someone that you trust personally, who have the ability to carry out those duties. So popular decisions are typically your spouse, a child, or multiple children, relatives, or close friends. There are 4 buckets when considering types of trusts. You have revocable living trusts, which are the most commonly used type of trust. And when most people think about a trust, they're thinking of a revocable living trust. These are created while living. They can be changed, altered, revoked later on, and assets within will still avoid probate. Second, there is a testamentary trust. These are less commonly used, but they're created under a will, and the testamentary trust is only effective at death. These can be easy to create or easier to create, and typically do require probate, though. Depending on the complexity of your state, there are also other types of trusts, including trusts used for tax planning. Examples might be a credit shelter trust, a Q-tip marital trust, irrevocable life insurance trusts. And there are also trusts used for other purposes: special needs trusts, asset protection trusts, Medicaid planning trusts. Trusts and wills have many similarities, but also a lot of differences. The similarity lies in that both documents dispose of your assets. Some differences are trusts avoid probate, wills go through probate. Trusts give greater control over when and how assets are distributed. Wills can be easier to set up. Trusts can take a little more work. Trusts apply during your lifetime, and wills nominate guardians and specify final arrangements. Trusts are usually paired with a will as a set. So when should you consider a trust? One reason is if you have younger children. Rather than having all of your assets go to your kids immediately when they turn 18, a trust can help you set triggers for asset distributions. Triggers could be once a child hits a certain age or some sort of life event. Maybe they graduate from school or they get married. So this can help stretch out distributions. Another reason to consider a trust is if you have complex family dynamics like blended families or second or third marriages. Trusts can let you benefit your spouse during your lifetime or during their lifetime, and then ensure that those assets then go to your kids and not to a second marriage or to stepchildren. Another reason is privacy. Wills become public through probate, whereas trusts stay private. And the final reason is if you have a higher level of assets. Trusts avoid probate, which in California typically kicks in around $160,000 in assets. With trusts, you can minimize estate and income taxes. So that federal estate tax kicks in around $12-13 million today. That could be lower at any point in time due to the administration in office and laws that change. Trusts provide for the opportunity for more advanced planning and can help you stretch retirement distributions as well. So we've covered wills and trusts. Let's talk about the third of the most common estate plan documents, which are healthcare documents. Typically, these are divided into 3 different types. You have your power of attorney, healthcare directive, and a HIPAA authorization. These three documents cover what happens when you are incapacitated. So while a will or a trust covers what happens to your property when you die, this part of your plan covers your wishes for your finances and care while you are still alive. Your power of attorney designates someone to make non-medical decisions on your behalf. So those are financial decisions, business decisions, any day-to-day transactions, bills, things along that line. You've got your healthcare directive or living will, which specifies your medical preferences in advance and designates someone to make other medical decisions for you when you're not able to voice them for yourself. And then your HIPAA authorization, which you may have signed at a doctor at some point, ensuring that your designated agents and representatives can speak with medical providers. So they can make decisions, consider costs of treatment, and also ensures that stakeholders in your care have access to your private health information and can communicate with care providers about medical history and decisions, which is frequently overlooked, to be honest. So who needs an estate plan? Really, all adults need an estate plan. And some common reasons to create one: triggering events, getting married or divorced, having a child, another child, a grandchild, adopting a pet, accumulating assets over time, running into any medical concerns for you or a family member, dealing with the death of a loved one, approaching retirement. There are many different triggering events throughout your life. And your plan at the end of the day should evolve as your life evolves. So you'll want to make sure that your wishes are constantly being reflected as your life changes. So some changes that are common are updating beneficiaries, changing guardians as your kids get older. They may need a different guardian. Generally speaking, you'll have different preferences as your life changes. Some common triggers for updating a plan are major life events, births, deaths, changes in marital status, retirement, and just the general passing of time. Every 3 to 5 years, it's definitely worth taking another look and revisiting your estate plan. And as children become adults, they need their own plan. So while your child is under 18, you have parental rights. However, once your child turns 18, they'll need to have their own legal documents in order to let you act on their behalf. Once you've chosen your plan, you'll only need a few things to get started. I promise it's not as intimidating as you think. It's mostly basic information like you, your spouse, and children's full legal names and birthdays. You'll need an idea of who you'd like to act as guardian for minor children and who you'd like to appoint as an executor or trustee. And you'll want to know, generally speaking, how you might like assets distributed. You can do it based on percentages or dollar amounts and who specifically you'd like to send certain assets to. So you can include jewelry, your car, cryptocurrencies, or you can simply just state a portion of what's left behind should go to this child and this child. So lastly, you'll need the names of financial institutions, which are where you hold your accounts, as well as the addresses to any real estate you may own. And if you happen to own a business, the names of those businesses as well. But that's it. Things that you will not need are social security numbers, bank account numbers, online passwords, real estate titles, or any relevant business ownership paperwork. So like I said, it's really not as complicated or scary as most people assume. And if you aren't ready to get started, you can always hop over to our website. We've got a ton of educational resources, articles, videos, you name it, on every topic of estate planning to help you feel a little bit more educated on this topic before you go ahead and get anything done yourself. You'll also have representatives from our team to hop in to answer any questions and support you through the process. So on that note, I wanted to talk about how technology like Trust and Will can help you get this done today during your lunch break if you're chewing away right now off screen. And so Trust and Will, we are the largest digital estate planning platform in the country. We've helped over 500,000 families in all 50 states to create their estate plans all online, saving over 70% versus what you would spend working with a local attorney to draft these documents. We're working and we've partnered with California Coast Credit Union to finally help you check this off your to-do list and to actually pass along an even greater discount off of our end services. So you get a 15% discount off of any estate plan purchase through our website. So that's some added value for just being a member of the credit union. So we're making this affordable for you. We're making this accessible for you. You can do this from home. You don't have to go track down an attorney you hardly know and trust them blindly to get this done. If you've ever used TurboTax before, that's a very similar experience. You're going to answer one question at a time as you move through these documents, and we'll help you to create your plan. This screen I'm realizing right now shows a 10% discount. You all actually get a 15% discount off of your estate plan purchase. We have two major packages today, a will-based plan and a trust-based plan. Your will plan is going to include your last will and testament, living will, HIPAA authorization, and power of attorneys, all state specific, all designed by our team of attorneys, but customized to the needs of you. That starts at around $140, $135 with that 15% discount. And then we have a trust-based package that includes everything in that will package, as well as a revocable living trust. And so if you own a home or have a slightly higher level of assets, a trust is going to be really great, especially if you live in California. And again, it comes in around $500 after the discount. It's going to save you hundreds, if not thousands of dollars versus working with an attorney. Typical attorney costs $3,000 to $5,000 to draft your trust and supporting documents. And how does this work? A lot of times people still won't necessarily know, is a will or a trust best for them? You can start on our website with a quiz, answering a few questions about your life circumstances. From there, we'll guide you to a document that may be a better fit. And all you're doing is answering one question at a time as you move through these documents. You can, at any point, save your progress, come back to it later. You have a question mark with additional context related to any questions being asked and implications, as well as a chat bubble that opens up a direct line of support with our member support team. And Jason on the call today is hopping in, answering your questions via the chat above, but him and his team are all available directly through the platform 6 days a week. So these are real people. They are employed by our team. They're not outsourced, and you can hop on a phone call with them. You can email back and forth with them. You can chat with them. But at the end of the day, they're there to make sure that you feel comfortable getting this done. You have your hands held. And on top of that, if you would like to speak to an attorney, if that would add greater peace of mind for you, knowing documents have been reviewed by an attorney, you've sat down and spoken with them about your wishes, for an additional $200 flat fee. So no, hourly attorney rates being charged. Flat fee, $200, you can speak with a local attorney to review those documents. So as I mentioned earlier, 15% discount offered through our partnership with CalCoast. The way you access that discount is you go to your CalCoast Credit Union website, search for estate planning, and we have a link here that we'll add to the chat itself. But at the end of the day, you click the link within the estate planning page, it'll say get started. You click that link, the discount code will be automatically applied at checkout. You'll see above that there'll be a welcome banner welcoming you as a member of the credit union, and automatically applying that 15% discount at checkout. So we're here to help you get this done. Again, this is the largest financial transaction of your entire life. So it's something you should take seriously, and it would be great to finally check this off your to-do list. It's going to make you feel good. It's going to give you that peace of mind and sense of relief. And it really outlines the legacy you want to leave. So they're important decisions. So we're happy to help you finally get this task accomplished. That is it from me. I think we're going to open it up to any questions people have. Will's going to jump back in, but thanks for your time.
O'Neill, that was great. Thank you. There's a lot of great information there. As a reminder, everybody, if you'd like to ask a question, use the Q&A function at the bottom. We have Jason Young from Trust and Will facilitating and answering those questions for you. We do have some questions, O'Neill, and you and Jason may be able to kind of chime in. Can an annuity be put in the trust?
Jason, would you like to hop in?
Sure. So yeah, I mean, an annuity can be put into the trust. Like we don't have any parameters on what can and cannot be put into a trust. But the thing is, every financial institution is going to have their own ways to transfer things into a trust. So you need to contact the company that's offering that annuity or that you have that annuity through to see what you would need to do to actually put it into a trust.
Perfect. Thank you. Okay, we have another question that came in. Can I put all the assets in a trust in California and become a resident in another state while the trust is active?
Yes. Once your trust is signed and notarized, it's legally valid in all 50 states due to Article 4 of the Constitution, which basically just says full faith and credit in all other state laws.
Thanks, Jason. And along with that, what about residency and citizenship of beneficiaries or successor trustees? Is that a requirement to be a US-based address or citizen?
No, they don't have to be a US citizen or anything. The only thing that could cause issues would be logistics. So if that trustee has to come to the States to, administer the trust, or if there are physical items that are being given to a beneficiary outside of the US, how to get those items from the US to a beneficiary that's outside of the States.
Okay, thank you. Also, is there, there's a question about the process. The question is, there's a lot more to do than provide the initial questions and answers. Does your service handhold us through the funding process? Does Trust and Will handle that on our behalf?
So we include a trust funding guide with all of our trusts to help you through, how to transfer various assets into the trust. Now, while we don't directly offer that as a service, we are partnered with 2 companies that can help. And you can get more information as you're setting up your trust through us about those companies that can help you transfer real estate into your trust.
Okay. Another question. Once we set up a trust and will, what is the process and cost of updating our preferences every 2 to 5 years?
Yes, so we give you the first year to make as many updates as you would like. And then if you want to make updates after that initial year, our membership's required, which it's $19 for a will and $39 for a trust billed annually to give you another year of updates.
Oh, perfect.
And that comes with other features as well. We have a digital vault where you can securely store your life insurance documents, the deed to your home, your birth certificate, and any other related sort of like important documents that your family will need to go dig up from filing cabinets, security boxes, or whatnot. So you can store everything in one place and only provide access to it if something were to happen to you, to your beneficiaries. So there's other value associated with that membership. If you decide not to opt in for the membership, there's no problem at all. You can always 3, 4, 5 years down the line just repurchase your will or trust from us for, again, it's $150, $400, $500 to get this done. So it's still going to save you a ton of money compared to working with an attorney. So that's your other option. You don't need to opt in for our membership, but you can always repurchase the documents at a future date.
And with that, do you review existing trusts? And if so, what's the cost for that?
We don't review existing trusts, as we're honestly not attorneys here at Trust and Will. I mean, while our documents were created by attorneys specific to each state, we don't review existing trusts. If you're looking to update your existing trust, there's a couple of different things that go into that. I would recommend emailing us at support@trustandwill.com. And we'll ask you a few questions just to determine if that existing trust can be updated through our platform.
Great, thank you. Another question. After putting my bank accounts in a trust, do I withdraw and deposit the funds in the same way? That might
You
be.
do.
Go ahead.
I mean, you do, like because even though those assets or those financial accounts are in a trust, you own the trust. So you still have full control over everything in it. So you could withdraw money, deposit money, everything like that, as if it was only in your name.
the next question, trust plus for $200 extra. Is that best for complicated estates? What is considered complicated? This individual owns 5 properties. Would that be considered complicated?
That's not considered complicated per se. I mean, the $200 additional fee, that's for attorney support, where it's available in certain states and it gives you unlimited consultations with that attorney about your estate plan for a full year in 30-minute blocks. So a complex estate would be something like if you want to set aside money for your child for, they could only use $50,000 towards the purchase of their first home. Basically, you know, strings attached to that distribution. That's what we consider complex estates.
Okay, perfect. Thank you. Let's see. In regards to your fee structure, question is, if I only want to update the trust every few years, do I only pay the $39 fee in the year I want to do the update? Or do I pay the $39 per year every year?
So you can opt out of the membership at any time. And then if you want to make updates, you know, 2 or 3 years from now, you would just need to pay the $39. We're not going to back bill you or anything like that for any months that you did not have the membership.
Perfect. And then Andres, this question may be for you or Jason. How long is the 15% discount? How long does it last?
I'll leave that one up to you, Andres, if you know.
That is a great question. I'm not 100% sure, but I have left my information in the chat box with my cell phone number and my email address. If you would like to email me that question, I will do some homework and get you an answer.
Thanks, Andres. And thanks for putting your information in there. So if anybody has any questions about any CalCOAST product or service related questions, feel free to put those in the chat, or look for Andres's information in the chat. Are there any other questions that we could for O'Neill or for Jason or Andres or myself? Let's see. I have another question. I see my primary home while in a trust. Do I lose tax advantages that I had with my primary residence? And does it affect other tax breaks if it's sold in a trust?
So our trusts, while they're revocable living trusts, they're also what's referred to as a grantor trust, which essentially means everything is treated as if you own it directly. So there's no difference in taxes for anything in the trust.
Okay. Do you guys do special needs trusts?
We do not. That's something we're looking into, but I honestly do not have a timeline or anything like that as to if we're going to offer it or when we are going to offer it.
Okay, perfect. Thank you. This next question is, while I'm not sure you don't intend to go out of business, what would happen to our trust and will in that case?
So it'll still be a legally binding document. The only thing is you just won't be able to update it through us, you know, since we would have hypothetically gone out of business in this situation. So, I mean, it'll still be legal. You'll just most likely have to go to an attorney to get your estate plan updated.
Perfect. Thank you. We hope you all learned something new and beneficial today that you can put into use. We'd like to enjoy the rest of your day. Thanks again for taking the time out of your busy day to join us, and we'll see you all next month.